So I think moving on to the next slide here, step 3 would be the decision. And it says, I've made a decision, Pauline, we're putting everything off till tomorrow, which is a lot of what I'm seeing with employers. They're not making a decision on this. I think they're worried. You know, they don't, I mean, it's kind of like, it's weird. It's like the employer's kind of worried about what's going to happen, and so is the employee, because it's like this weird like chicken thing, you know? Like, are you gonna, if we don't give you the exemption, are you gonna get vaccinated or not? You know, I'm sure a lot of people have gotten the initial indicate your vaccination status, and you know, we just want to know, are you gonna try to get it, you know, or are you not gonna get it? And they're trying to do their numbers and everything. And a question I get about that, which I'm probably already covering, now I don't even need the frequently asked questions slide because I'm already covering them, but is a lot of people will say, and this is probably the number one mistake I see from people, is their employer will say, I want your vaccination status. And then a good constitutional American, like, you know, you and I both are, will say, well, you don't have the right to get that from me. And you know what? I agree with that. Unfortunately, the law does not agree with that. Unfortunately, an employer is entitled to ask you for your vaccination status if it has to do with an issue of workplace safety. So they can actually get medical information from you if they have a compelling need to, you know, protect the workplace. Now here, obviously you and I both know, there is no compelling need, there's no issue of workplace safety. We already went through all of that. I'm not a danger to anybody if I don't get the vaccine, but you know what, it's just the world we live in, that they do get to ask that in this situation. So all that's to say, don't make not disclosing your vaccination status the hill you die on, unless you're, I mean, if you want to make that the hill you die on, more power to you. The only thing is, you're going to be without a job and you won't be able to sue them later. You won't have a claim, because you can't really sue an employer over that. I mean, there's maybe a small argument you can make, but it's not likely you're going to succeed on that. So I just want to throw that out there. I actually had to save somebody from doing that yesterday. I saw an email. I was super busy. She's like, yeah, they're going to fire me tomorrow. I'm not going to tell them my vaccination status. I was just like, no. I called, don't do that. So after the interactive process is done, they'll either accommodate you or they won't. And if they say, sorry, we're not going to give you your exemption, then you can, well, you know, why? what's the basis for your denial? You're going to want to ask that. And if they say, well, I mean, they could say one of two things. Like I said, either they don't believe your belief is sincerely held, or they don't believe that you actually have a medical condition. That's one basis, and then you can kind of argue with them about that. Or your accommodation is not a reasonable accommodation to them. And then you can kind of go back and forth. Okay, well, what's unreasonable about my accommodation? And you can kind of negotiate a little bit. It just depends on the employer, like I said. So, yeah, and then if it's denied and there's no agreement that you can reach with them about the accommodation, they're just going to be that crazy about it, then the next step would be to file a charge of discrimination. Now, unfortunately, a lot of people think that you can just turn around and sue your employer if they discriminate against you. And that kind of is the case, as we've seen with the United Airlines lawsuit and the Southwest Airlines lawsuit. And the reason I say kind of is because the law requires that you exhaust your administrative remedies prior to making a legal claim against your employer. And exhausting your administrative remedies means that you must file a charge of discrimination either with your state's employment agency or the EEOC, the Equal Employment Opportunity Commission. And you have to do that within 300 days of the adverse employment action. So that would be within 300 days of whenever they informed you that you're terminated or you're demoted or whatever. So I tell people to file with the TWC, and the reason for that, just generally right now, I don't think the federal government is your friend at all. So I think you're better off trying to go through the TWC. You can't file individually, separately with both, but filing with one or the other counts as filing with both. They have a work share agreement, so if you file with the Texas Workforce Commission, they will forward your charge of discrimination over to the EEOC, and it counts as filing with both. And one or the other will resolve your charge. And they have, by law, they have to do it within 6 months. Now, I've seen the EEOC take over a year, and it's really just annoying, because you have to wait all that time to know whether you're gonna be able to sue your employer. And so after this, they're supposed to do it within 6 months. So after 6 months, or sometime within that period, they send you a letter, and it's your notice of right to sue. And at that point, then you can file a discrimination lawsuit against your employer. Now, that gets to why are we seeing these lawsuits from the United workers and the Southwest Airlines and some other folks. You can actually bring a lawsuit to get a injunctive relief. Injunctive relief is when you ask the court to do something that's not awarding you monetary damages. So, a temporary restraining order, probably most people have heard of that. Injunctive relief is to preserve the status quo until something else happens. So in this case, you're telling the court, hey, I'm about to get fired, and the standard is you have to show immediate and irreparable harm. I'm gonna get fired, I'm gonna lose this job, and there's really nowhere else I can go because all these other employers are mandating the vaccine, so I need you, court, to just put a hold on this until my charge of discrimination is resolved. And then, I'm kind of waiting on pins and needles to see what happens in that United Airlines case, because the court, I don't know if you saw in the news, the court did grant the temporary restraining order, but there's two steps. There's a temporary restraining order, and that's only supposed to last for 2 weeks. It can last for up to a month, depending on the circumstances. But in this case, the court said, well, I'm not gonna, generally courts have to grant a TRO if they think the case has merit, but in this case, the judge has said, I don't know if the case has merit or not, but all these people are about to lose their jobs, and I'm just gonna delay this. I'm gonna say, United, you're just gonna have to wait a little longer until you terminate these people, and then they're gonna have an evidentiary hearing coming up. I don't know which date that is, I gotta look at the docket, but that's when the court will hear the evidence and say, you know what, I think this case has merit, or I think it doesn't, and if the court thinks it does have merit, then they'll put that injunction in place and keep United from firing their employees until this charge of discrimination is resolved, and then until trial after that. So that's kind of the whole process of going through. So the last part would be actually filing a lawsuit. And so I kind of just already went through that. It's after you receive the right to sue. The law, Texas law says that TWC has 180 days to investigate your claim. Now, when I say investigate your claim, sometimes the EEOC or the TWC will decide to take on the case themselves. It almost never happens. I've literally never seen it happen in my practice even a single time. 99.99% of the time, they will just say, hey, here's a notice of right to sue, and you can go ahead and sue your employer yourself. It would have to be something really, really bad for the EEOC to actually take a direct action against your employer, but it does happen from time to time. Already went through the restraining order part. Okay, so what is a class action lawsuit? There's been a lot of talk about, we need to join a class action, we need some class action lawsuits. So a class action lawsuit is when you have a lot of plaintiffs. A plaintiff is a person who is suing the defendant, the person or entity that has wronged them. And you can have a class action lawsuit if you have a bunch of plaintiffs who have all been injured in the same way by the same person, generally under the same set of facts, and that's called similarly situated. Try to say that 5 times fast, it's very difficult. So if you have a bunch of plaintiffs who are similarly situated, then you can join them all in a class action lawsuit. There's a bunch of different, you have to show, the similarly situated thing, you have to show numerosity, there's too many, so it's impractical to join them all in this case. There's a common set of facts. Here would be everybody got terminated because they filed a religious exemption and they all got denied, or they all filed a medical exemption, they all got denied. So that, and you will name the employer, and you can name multiple defendants. It just depends on the situation. But generally speaking, the class action lawsuits in this context will be like we're seeing with the United Airlines and the Southwest Airlines case, where it's all of the people that got fired by that one employer, and they band together and do a class action lawsuit against the employer. So that's what we mean when we're talking about class actions. And it's, I do say it's actually more, people get excited about a class action lawsuit. They're just like, oh wow, there's all these people suing this one employer. It's actually better for the employer if it's a class action rather than individual lawsuits, because just think about it this way. The employer either has to deal with one lawsuit. Let's say there's 100 people wanting to sue the employer. The employer has to deal with one lawsuit from 100 people. That's way easier than dealing with 100 separate lawsuits, right? That's gonna cost the employer a lot more in legal fees if they have to deal with 100 different lawsuits. And so it's actually better to sue individually for that reason. It kind of gives you some more leverage with the employer. Now, and this is all just kind of context, but the court could consolidate the cases. That could happen, but generally speaking, it's better sued individually. But the thing is, a lot of us don't really have the funds to do that. It's very expensive to pay a lawyer to sue your employer, and a lot of times, if this were any normal situation, what would happen is there'd be all these plaintiffs' firms, there'd be all these employment lawyers just licking their chops to sue all these companies and get all these plaintiffs because what they usually do is there's all these companies. It's a big business. If you know anything about plaintiffs' law, those are the richest lawyers out there. They make tons of money, and what they do is they get these companies to finance their litigation. The financing company will look at it and kind of go through the probability of success, and then like, okay, plaintiff's firm, unless you already have tons of money, you can fund your own lawsuit. We're going to fund you, and you're going to, it's like a loan, and they get interest, and they get there's stipulations on that. But in this case, we're probably not going to see that, unfortunately, because we know most of those companies are, they're left-wing companies, they're woke companies, they're banks. And so what we're going to have to do, if we really want class action lawsuits, we need to find some folks with deep pockets that are willing to finance this sort of thing. And it could be a market, it could be a business opportunity for some entrepreneurs out there who have the means and the capital to do this, or get together with a bunch of your friends who are in coworkers who are getting sued, and see what you can do as far as pooling your funds. And I'm kind of still trying to figure out the numbers and the logistics of this, but probably if there was like a $10,000 retainer or something, I think I would probably take a class action lawsuit. So if you can pool together those types of funds, and you want to have a conversation with me about that possibility, I'm happy to talk to you about that. I'm going to have to hire some more staff, so hence the retainer, because right now I have one assistant, which is great, she's great. But anyway, that's a class action lawsuit. So, and I'll take questions on that if there are any. Okay,